Well, thank you very much. And aloha and welcome to the Grassroot Institute today. It is June 23rd, 2020. I'm Keli'i Akina, president of the Institute, and just delighted that so many people are joining us today. We're going to get to your questions because I'm sure you have a lot of them for our two guests. I've got two constitutional attorneys who have been monitoring the coronavirus shutdown situation. They've got a lot to share about that. But before we proceed, you may know that yesterday, Monday, the state legislature reconvened here in Hawaii, and top of mind was balancing our budget, or at least finding a way to make sense out of our budget crisis that we're facing now. And we provided a tool to legislators, a tool to balance the budget in which you could play with the various assumptions. You'll find that available on our website, and we're pleased that many of the legislators have actually looked at that. In addition to that, there is a document that the Grassroot Institute has completed called Roadmap to Prosperity. These are 23 ways to get out of the economic crisis we are in and to put government and the economy on a good footing. With that said, we'll go straight to our topic today. Lockdowns, testing, and tracking. Are they really legal? Are they good? We've got some good thought on that today. My first guest is Jeffrey Portnoy, a partner with Cade Schutte, and he specializes in First Amendment issues. Jeff, thanks for joining us again at the Grassroot Institute. Always good to have your expertise.
Thanks for the invitation.
And in addition to Jeff, we've got another good friend, Robert Thomas, director of the law firm Damon Key Leong Kupchak Haspert. He's an expert in eminent domain takings in particular, and government takings otherwise as well. Glad to have you with us all the way from California today, where you're holding up because of the 14-day quarantine requirement in Hawaii, right, Robert?
That's exactly it, Dr. Akina, and thanks for the invitation as well.
Well, why don't we get the ball rolling by asking Robert to explain a little bit about a couple of lawsuits in Hawaii that have emerged, and our viewers may not know everything about these, dealing with the restrictions that government has imposed. You've been monitoring these very carefully. Why don't you give us a quick update on what's going on?
Yeah, thank you. First of all, we've seen a lot of these lawsuits being filed around the country, more than I can keep track of. But in Hawaii, we've had two cases filed against Governor Ige and the state government. Both of them have been filed in federal court, asserting a variety of claims, including under state law, what's called the automatic termination provision. And that's something I'm assuming someone will ask about during this, and we can talk about that, as well as some kind of uniquely Hawaii constitutional law claims, including the right to travel, separation of powers, equal protection, and due process. So just as an update, the federal court in the first case has scheduled a hearing open to the public by dialing in this Friday, is that right? June the 26th, so 3 days from now, 10:30 a.m. Hawaii time. And what we'll do at Keli'i is we'll give you the call-in instructions that the court has published, so people who want to listen into the hearing and the arguments can listen in. So for now, they've just been filed, waiting for any kind of a court decision, and that this Friday might be the first time that we actually see something from the court.
I'm going to ask you, Robert, a purely layman's type of question, as if you had a crystal ball. How much traction is there to these cases?
They're hard cases. I'm always loath to make a prediction about how a court will rule. I think that's a tough one. We're asked to do it all the time, but these are particularly hard cases. Anytime you're challenging the government's restriction on your liberty or property or the way you behave, there's always a presumption that the government is doing it correct. And even though there's not a different standard that the court applies during a public health emergency, I think institutionally courts are probably even more reluctant to get involved in these type of cases right in the middle of a public health emergency. And so, what starts off as a fairly daunting challenge becomes a little bit higher because we're in an emergency. That being said, I think there are at least one of the state law claims has some legs, and there's, I think, a very good question being posed by both lawsuits about whether the governor's power is terminated at 60 days. So, again, loath to predict, but we'll see. Let's put it that way.
Well, the court will rule, and then we'll know after the fact, at least.
We
Now,
will.
Jeff Portney. Let me go to Jeff for a moment. Jeff, you've been observing the situation, and you're a constitutional attorney. You have defended First Amendment rights, other rights as well. On one hand, government has a role to help protect the public, particularly in the kind of health crisis that the COVID-19 puts before us. But on the other hand, individuals have constitutional rights. How well do you think we've been balancing these here in Hawaii?
Well, I think it's a difficult question because it's not only legal, but it's medical/scientific.
Yeah.
It's political. I think a lot of it is how you view the politics of this situation, which is, I think, unfortunate. By the way, if I had $1,000 in my pocket to bet on what's going to happen on Friday, I do not give great hope to those seeking to overturn the executive orders, although, as Robert said, there is this kind of unique and strange 60-day requirement, which I need to admit I'm not really an expert on. But I'll tell you, the overwhelming number of similar cases brought throughout the United States have upheld all of the restrictions. There have been a couple that have gone the other way, including in Wisconsin, which a lot of people feel was a political, not a legal decision. But, 115 years ago, the United States Supreme Court ruled that the government could require a citizen to take a smallpox shot. And I'm not sure that federal courts are ready to change that 115 years later. But there are some things that I think are worthy of looking at. For example, when they did have the demonstration about a month ago down at the Capitol, and people were arrested and frankly harassed, I think that was a significant First Amendment violation. And I know a lawsuit was filed about that, and I wouldn't be surprised if those folks win, because that was not something that I think affected safety or health, and that was a First Amendment violation. When you get down to some of the other things that people are unhappy about, like the masks and the quarantine, I just wouldn't put my money on having those overruled.
Now, a lot of businesses are complaining of the losses they have suffered due to the coronavirus shutdown. And many of them are asking, if someone's business was hurt because of the government shutdown, does the government owe them compensation? Robert, what are your thoughts about that?
Short answer, generally no. In all but the most extreme circumstances in which I have not yet seen, the government is given a lot of leeway to regulate how you conduct business. And if you happen to lose money as a result of that, the courts generally do not require the government to compensate you for that. Now, again, like every general rule, there's some exceptions. And we've seen a lot of those cases that I've mentioned from elsewhere in the country claiming just that, saying the government gave me a permit to operate my business. It has unreasonably shut down my business for the public good. Therefore, the public should have to compensate me for the losses that I'm sustaining in my business. So far, none of them have met with any success. The closest that a high court has ruled on it would be the Pennsylvania Supreme Court in a case oddly called, of all things, the Friends of Danny DeVito against the governor of Pennsylvania. And it's not that Danny DeVito from Taxi, but yet he's a local politician claiming just that, saying that they were shut down. They suffered business losses as a consequence of the shutdown, and the state therefore had to pay them. The Pennsylvania Supreme Court, over a dissenting opinion, said that's not a problem. And then when the Friends of Danny DeVito took it up to the U.S. Supreme Court on an emergency order, seeking an emergency stay, the Supreme Court turned them down for exactly the reasons that Jeff mentioned, that this is one of those things where, the courts will defer extensively under that Jacobson case on the inoculations to the government's, in that case, it was the governor's judgment about what constituted emergency and what were the right means to address it.
You know, this
Thank
is
you.
very curious because following up on this, there are a number of lawsuits throughout the country brought by insureds against their insurers for these exact claims of business losses under the interpretation in various policies dealing with the force majeure clause and whether governmental action closing down a business is insured. So far, none of them have reached a conclusion, and there are lots of different policies out there, including a number in Hawaii, by the way, that deal with that. But what I think is ironic, looking at your question about government, you know, there's been a movement among some federal legislators to change a law, to pass a law requiring the insurance company to pay for those damages, oddly, probably to prevent the government from having to face those suits. I don't think that law has any chance of success, but even the fact that it was being discussed and probably is still being discussed shows sometimes how government works.
Yes,
Yep.
it's the government's way of trying to seek some sort of insurance policy for itself. You know, there's been a lot of talk also about privacy and the so-called right to privacy. How far does the Constitution, both the federal and the state Constitution, go to protect privacy? And in particular, let me throw this to you, Jeff. Lawmakers want to use facial recognition cameras at the airport. That's raised a lot of concern about the right to privacy. Your thoughts on this?
Well, first of all, there is no federal constitutional right to privacy. It's not in the Constitution. It was a Supreme Court creation. There is a state constitutional provision for privacy. And I've spoken on this publicly. I think facial recognition is likely to be constitutional with severe limitations. And I don't think anyone should just go in there and say to the state, yes, you can do facial recognition, because we've seen tremendous abuse in facial recognition. And in fact, several entities like Microsoft now will no longer assist in facial recognition because it's been used primarily to find, quote, criminals, close quote. But I do think, looking at what's been going around the country, to the extent the state gives you the right to refuse, to the extent that the state makes it clear that they're not going to use facial recognition except for COVID-related purposes, probably would succeed. But I'd be a little bit concerned about facial recognition, although I think in these times, probably with the right restrictions, the state could get away with it. But I think they're even moving away from it, knowing the constitutional challenge they're going to face, Bob.
Yeah, and Robert, let me give you a couple of other examples. For example, the tracking, the use of telephones to track people, or tracking people via social media or various AI-equipped apps and so forth. Does that constitute a violation of privacy? And let me throw in there as well the kinds of screening questions that are going to be asked as people travel inter-island, especially requests for information about their health conditions.
Yeah, I mean, I'll start with Jeff's basic premise, which I think is absolutely correct. But you also want to take a look at non-constitutionally based rights to privacy. You know, you may have a certain privacy right as a result of, say, federal medical privacy statutes, HIPAA and the like. So you want to look at those. And I think it's a area where if it is not automatically or not obviously a violation, a lot of these things that I've been hearing about in order to track people or to ask them questions really come right up to that line, wherever that line might be. They're really close. And so I think we do see the state acting in a very careful manner because they're afraid of the lawsuits that might come if they go over that line. Now, the state, I think it's pretty obvious that its interest is in protecting the public health, but like everything else, it's limited by both federal and state constitutional law, and to some degree, maybe by federal statutory law about what they can do and what they can ask. So I don't think that the the basic rules change. So if they can't ask you these things during normal times for normal reasons, and the thing that I'm thinking about the most is, last time I was on a plane to Honolulu was so long ago, I've kind of forgotten, but they hand you the two-sided form, the two-sided form, and they tell you, you gotta fill this thing out and tell us where you are. But if you look at the very bottom of that, it says this is all optional. This is for data collection purposes for the tourism authority. And yet some of the key information on the other side, do you have a banana with you that can't come into the state because of the fruit quarantine? Those are mandatory. So I think you may see a lot of these suggested response type of questions without maybe some backup of them, and then people, or the government at least, hoping that people comply with them as a matter of good faith, even though it's not absolutely required. And I think that's maybe where you're going to see a challenge, and at least one of the challenges that have brought up in the lawsuits that I have mentioned about the right to interstate travel. If there's too big of a burden on that, an unreasonable burden, the courts in limited circumstances have struck those down.
One of the biggest problems that is being faced right now in the economy is the shutdown of our airports, or the virtual shutdown of our airports through the disincentive of the 14-day quarantine. So government is looking at ways of lifting that. And one of the ideas that came up recently was the issuing of a health passport. In other words, certifying that someone like you, Robert, when you want to come back here to Hawaii, is COVID-free before you are allowed to travel to Hawaii. Now, I thought about this a bit and wondered if businesses could do it on their own as well. Either way, whether the government imposes this or businesses adopt it on their own, are there any constitutional problems here?
This is nothing new, though, Kalihi. If you travel around the world, and even if you come back to the United States, you have to answer health questions every time you come back to the United States, having nothing to do with COVID. So this is just an additional disease, unfortunately, that now will be on forms, and you'll have to use it for interstate travel, where that was never done. But if you come back to the United States from a country that, for example, has had a Ebola outbreak, you're asked. If you go on a cruise ship, you're asked about whether you've been exposed to certain diseases even before this. So, there's I mentioned the word politics earlier, and it really has gotten involved way too much. And you look at the face mask issues in various states, where now wearing a face mask is a sign that you're either a Democrat or a Republican. I mean, it's really a sad situation. And I'm not arguing, whether you should or shouldn't wear a face mask on scientific basis. I certainly don't have, lucky I passed biology in 10th grade. But it's no longer based upon science. And you just listen to people and read what's going on in certain states. It's become kind of a blue state and a red state thing. And I think that's really what's affecting even some of the things that are going on here. I think people who are politically conservative or more to the right than people, maybe more to the left, are offended and taken back by a lot of the restrictions that are put on. And it's not, it's got nothing to do with the science. It's got to do with your belief in individual rights and liberties. And sometimes you have to look for a balance. And I think that's what people are trying to do. So I've gotten I'm sure Robert has too, emails and calls for 3 months to bring lawsuits by, for people. And I can tell right away what their politics are. So it's a difficult thing. And I think, whether the state should have shut down or shouldn't have shut down or should be opening up more quickly, unfortunately is gotten confused with politics rather than science. And that's the difficult thing.
Right. Well, let's talk briefly about information gathering that's taking place. One question is, can the government require private businesses to collect health information on their constituents, on their customers? And secondly, can the government require that kind of information be handed over by private businesses?
I'd say no to both.
Yes, I would agree, both on constitutional grounds and on
HIPAA.
HIPAA, the medical privacy statutes, and just holding that data subjects someone to potential liability if it gets out. So not only do you have to worry about crossing swords with the government on that, but then also if you don't maintain the data, as I recall, and I'm no expert on that statute, but as I recall, that subjects the holder of the data to some kind of potential liability. And maybe an example from a recent case from the Ninth Circuit out of Los Angeles is where they require, I think it was the city of Los Angeles required hotel owners to gather data. They on their there are people who register for the hotel, and the city went and required them to disgorge that data. We want to see who's staying there. And I forget the exact reasons why. The hotels rightly objected, and ultimately the Ninth Circuit upheld them, saying that that would have been an illegal search and seizure, and they had a duty to keep that data private. So I am with you, Jeff, on that one.
That's why you see the signs outside of a restaurant, for example. If you've had a cold, don't come in. That's fine. But if the proprietor would have stopped you coming in and saying, have you coughed in the last 24 hours? I think that would be a bad thing for the proprietor to do. I mean, you can't ask people about their disability regardless of COVID in many cases, including the government. So again, there's a balance, and that's why I think you see the sign and not somebody sitting there questioning you on your health.
Right, public
All right.
accommodations laws, right?
You've obviously pointed out the restrictions we have against collecting and requiring health information disclosure. What about disclosures as to our location? What about that kind of information?
If you're in Russia or China, you have no choice. They're tracking you every second of the day on your cell phone. I personally, to be honest, and again, I don't want this to look political. If the government was tracking me on my cell phone, I'd get rid of my cell phone. They can't force me to have a cell phone. I think there are serious issues, like flying a drone over your house. I think that's a blatant invasion of privacy. So I am not a big fan. I think that's something that could be worth challenging. It's a balance, but I think if you were being forced to let the government know your location every second of the day. Now, by the way, that's happening all the time, pinging off of cell phone towers. How do you think they find criminals, for example? But you're voluntarily allowing that to happen. To be forced to do it, I think, Robert, that would be a serious challenge.
Oh, yes. And we've seen a little bit of that. Luckily, we haven't seen that type of requirements coming out of Hawaii's governments yet. But for example, I know of a couple of instances across the mainland where the local county health department says that it will refuse to issue back to work orders unless the employers require the employees to download an app on their phone and then input every day their location, where they go, their body temperature, and have you exhibited the following symptoms of COVID, and absent checking off all the right boxes and supplying the data, you are not allowed to go back to work. And I think that has severe challenges legally and even morally.
Let me just say this, Kali'i, find the right federal judge, depending upon what side you want to come out on. If you get someone from the Federalist Society, you might prevail in finding that these restrictions are unconstitutional. If you find a judge that might have been appointed by a different president, you're going to lose.
Well, Jeff and Robert, thanks for getting us started. We have a very well-informed audience, and I want to thank all of you for listening so far. We're going to hand over the better part of this hour now to audience members. Several of you have submitted your questions, and I invite more questions at this time. To field your questions to Jeff and Robert, I want to invite back Joe Kent, Executive Vice President of the Grassroots Institute. Take it away, Joe.
Okay, yeah, we have a lot of great questions and keep them coming. Um, Ken Middleton asks, what's happening with the state of Missouri AG class action lawsuit against China for COVID damages? Uh, and is anyone in Hawaii doing the same thing?
You want me to take that one, Jeff?
I'm not,
Okay.
I know of
Where
it, but I'll let you take that one, definitely.
just by way of background, there's been at least one lawsuit filed by a state attorney general, and I think it's Missouri, but I can't quite confirm. I'll leave it to our questioner to confirm that, suing the government of the People's Republic of China for all the damages caused in Missouri for the COVID outbreak. Does that have a chance of going anywhere? It's as if any lawsuit I've ever seen has a 0 chance of winning, I'm afraid that one is it. So that's my first, where's that one going? I think it's going down a dead end towards this quick dismissal. Have any other state AGs undertaken the same approach? I hope not, because I think it's a total waste of time.
How about a suit against the President of the United States?
No, there you
I'm
go.
just saying, I remember
Yeah.
I talked about politics. I mean, you could argue the same thing, that the present administration is responsible for a lot of what's gone on. So, yeah, I don't disagree with you. I mean, it probably made a nice headline for the Missouri Attorney General, who's probably elected, not appointed.
Yes. That's like chopping
Okay,
up red meat for his voters.
Right.
For her voters.
another question from an anonymous attendee. Lots of First Amendment violations going on with protests, but what about the Black Lives Matter type of protest? There were thousands of people there, yet it didn't seem like there were any of the same type of citations.
Well, again, we're talking politics. I mean, there are some issues dealing with face masks. I mean, in jurisdictions now, and there are more and more every day that are enforcing or making it mandatory to wear face masks. If it's voluntary, then I think it's a non-issue whether you wear one or not legally. Even in Hawaii, I mean, some people wear the face mask and some people don't. Um, uh, this is a difficult thing, and it again, it intercedes, intersperses legal with politics, and um, uh, I think it depends a lot upon where you're protesting and who the leadership is, and your own political beliefs. So when you mix COVID in there, I mean, look what happened just the other day in Tulsa. You know how much controversy there was about holding this rally indoors and whether it should have been indoors. And, people were being asked to sign a waiver, giving up their legal rights if they contracted COVID-19. Was that political one way or the other? Some people wore masks, most people didn't. I just think it's a very difficult dilemma, but I'm a big First Amendment guy. So, as long as there's no destruction, you're just going to have to put up with it. And I'll tell you, if I was on the freeway and Interstate 75 in Atlanta, where I've been many times trying to get through, and I was stuck there for 6 hours because there were 200 people blocking the road, I'm not sure about my First Amendment beliefs.
We have a few questioners who looks like they've raised their hands. Chuck Thorne, I'll bet you have a good question, but try to type it in instead of raising your hand. I'd love to hear your question. Joreen Knox asks, if we filed a federal class action suit against the governor, would that be more productive, specifically against the mandatory quarantine?
I'll take that one.
All yours, Robert.
Yeah, I don't think there will be much in terms of substantive difference between a class action and the current non-class action lawsuits that have been filed. Both of them, if I'm recalling correctly, are by a wide range of individual and business and association plaintiffs. They're not styled as class actions, but and that's seems appropriate to me. I don't think you get any more traction on the case or the arguments if you style it as a class action, if that was indeed the question.
I think you'll get a hint, by the way, on how these lawsuits are going by the fact that they are going very slowly. If there was merit you would have seen preliminary injunctions granted all around the country, because by the time, for example, the Hawaii cases are decided as to whether the governor could or could not do what he did,
Yep.
we'll be long beyond any of these things that are going on, just because that's the way courts operate. So unless you get a preliminary injunction, you kind of get a hint on how the courts are looking, and maybe even the parties are looking at the merits.
Going to that, Mark White asks about, when this all expires, let's say the governor's emergency order eventually expires, then what specific actions are required to continue similar restrictions? I mean, I guess the governor would just have to declare another emergency order, right?
Well, your questioner has hit upon what I think is the big substantial question in both of these lawsuits, that automatic termination provision that's baked into our statute. I mean, by way of background, our statute, Chapter 127A of the Hawaii Revised Statutes, go read it. It's short. It's written kind of in plain English. The legislature delegates a huge amount of power to executive officer, particularly the governor, and in case of a local emergency, to a mayor. The one check on the governor and the mayor's power is that all emergency proclamations end automatically no later than 60 days after they're issued, or earlier if the governor or the mayor, for example, puts into their proclamation a fixed end date that's shorter than 60 days, or the governor or the mayor issues what the statute calls a separate proclamation. So when you listen into the arguments this Friday, I think that's the argument that you should be looking for. Governor Ige has, for instance, issued, I think as of last count, a series of 9 supplemental proclamations that effectively pick up and incorporate every existing proclamation and bring it along. Is that going to qualify as the separate proclamation required by the statute? Now, you look into all the testimony and the history of the statute, and it tells you a big fat zero about what that term means. And you can't even look to other states, because other state statutes, almost every single one of them, tells you what happens at the end of an automatic termination of a declaration. It says the governor may renew, the governor may go to the legislature to ask for renewal, the governor may issue a new declaration of emergency. I mean, I don't think anybody's claiming that the governor loses power at 6, if a emergency lasts 62 days, that we're unable somehow to respond to it with government authority. But in these type of cases, process matters. So, I mean, the most sort of startling example of this is the local emergency that on Kauai, I think, has been ongoing for 2 years now, into its 15th iteration. And at some point, a court's going to see that this looks like, government action by decree, governor or mayor decree, than it does by the legislative process where we, the people, are involved.
Well, so all they have to do, Robert, this is, so let's assume the court says that he has violated that statute by not issuing a new proclamation. He'll just go write one.
Yeah.
We'll get the exact same thing for the next 60 days. Sometimes people have to think through what the end result is going to be. And if these supplemental ones are in violation, and I hear you, and they may well be, so what? I mean, he'll just put them into a brand new one. So, what have you accomplished, I guess, other than to maybe embarrass the governor?
My thought is this, and perhaps I'm seeing this more as a lawyer thinking
always a
about,
bad thing.
Exactly.
Always a bad.
Thinking about sort of the overall why is there a 60-day provision in there at all? There's at least 2 states that says the governor may act as long as the emergency continues. So essentially appoints without making a too strong of a statement, a very strong muscular executive for as long as the emergency continues, as determined by the executive. So it's kind of a scary amount of power, and a lot of these limitations on government power that go to the separation of powers have that very result, that in the end, you can fix it by the right processes, but ultimately that would mean the governor would have to come back to us or the legislature and say, this is what I'm doing and this is why I think this continues. And
We've
I
got
think
some-
that from the long-term perspective, that has some value as opposed to the governor simply saying, I incorporate by reference all of my previous things. And, you know, it is a matter of the attorney general retyping a lot of it, but there is
Right.
some value in that.
It's kind of like a chicken and egg thing. Is it politics? Is it legal? And well, we have a lot of questions here I'd like to get to. Mark White asked another question. What's the burden of proof for a successful takings lawsuit on this COVID thing?
Okay.
Well, Robert's the expert on taking. I'm not sure on COVID, but if your property is going to get taken, give Robert a call.
Oh yeah. Well, thanks. I appreciate that plug. Your check's in the mail, Jeff.
Thank you.
But short answer is, if the governor, you know, if it's the rail agency taking your property to build the rail station, the burden's on them to show that it's for a public use, and the amount of compensation is correct. That's not what we're talking about in most of these COVID-related cases, because we haven't seen the Hawaii governor, for example, commandeer property like we have seen in some other places. New Jersey, and I think it was Los Angeles again, commandeered empty, unused hospitals for potential beds, or commandeered hotels to house the homeless. In that case, they acknowledge there's compensation, and then it becomes a fight over how much that's worth. But what I think we're talking about is claims saying that, well, you shut down the business, or you kept me from operating a hotel or a vacation rental, or something, you know, my hair salon got shut down for 3 months, and in the middle of that, I went out of business. What's the burden of proof? Well, first of all, the burden of proof generally is on the business, because it would be the plaintiff in these type of takings cases. And second of all, the Supreme Court and the Hawaii Supreme Court have established these tests for when these type of actions result in the requirement to pay compensation. And I don't want to get into the god-awful details of those legal tests, but I will tell you that it establishes a very high degree of deference to what the government is doing and why, and it allows even substantial, I mean, 90% plus loss of use and value to go by without the court stepping in and saying that there has to be compensation. So, you know, call me with your case and I'll happily evaluate it. But I think a lot of people get unhappy because about 90% of the people who come to me with those kind of questions, I tell them you don't really have that much of a chance of winning, and it's not worth you paying me to try to figure that out. You know, it's a daunting
Going
case.
on to some other questions. Joreen Knox asks, can they actually take you to jail if you don't quarantine after returning home from the mainland?
Yes. I mean, they're not. I actually know somebody who came back and got caught, and they got cited, and they have to go to court, and there's been some discussions about what might happen. I don't think any judge is going to put anybody in jail for breaking the quarantine, but paying a fine and doing community service, I think is quite likely. I don't think the government is going to just turn their head on people who are blatantly ignoring the quarantine, because it makes it an ineffective statute, which, by the way, it may be anyway. I mean, how many people can legitimately be tracked despite the government's best efforts? But I do think you're going to find people that are going to challenge it. There may even be 1 or 2 people that'll take it up on appeal because they don't want to pay the $250 and do 50 hours of community service. But I don't think anyone's going to jail simply for violating the quarantine.
Claire Waters asks, can we refuse to answer a question about having received a vaccine last year for inter-island travel, for example? If we don't answer, will they deny boarding?
Will they?
I'm not really sure I understand the
So
question.
basically, she's
No
asking.
one's gotten the vaccine yet.
Yeah, she's asking, can they ask you about, you know, did you get a vaccine? Can they ask you your health information and all of that as a condition to board an airplane?
My answer is going to be, and I'll let Robert do it. I think the answer is yes.
Yeah.
I think they can ask you if you've had a vaccine.
Mhm.
Not sure if they can ask you if you've had the disease, but the government restrictions on HIPAA are much different than private individuals. Whether they could deputize, for example, the airlines to ask those questions, that's a fascinating question that I don't have an answer for, but I have no doubt that in the proper circumstances, they can ask you if you've had a vaccine. And I don't know whether vaccine would be a requirement to get on an airplane. We're going to find out long before the vaccine, because if what Hawaii is rumored to be looking at, what Alaska's doing, for example, is giving you choice. Either you take this test 72 hours before you get on the airplane, and then in Alaska, 3 days after you get to Alaska, I believe is the second part of the test, or you get quarantined for 14 days. We're gonna find out whether someone's gonna try to challenge that again. If I had another $1,000, I'd say you're not gonna prevail on that.
Yeah.
Sure. Okay. We got a
Joe,
question. Yeah.
I don't mean to interrupt, but before we go on, I did want to make sure that you see there's some folks I noticed on the Facebook who said that they're asking questions, but they're apparently not pinging through. So I want to make sure
okay.
that you see those on your end, and I don't have a chance to read them, but I did see at least one comment like that on the Facebook stream.
I don't even know how to do that, so that's good to know.
Well, just we'll try to get to as many as we can. How about we do a lightning round then? We move into the lightning mode and try to answer within 1 minute. Chuck Thorne asks, can the government close a road to a remote community, calling it road repair, but really knowing it's COVID related?
Like on Kauai, you mean?
Like on Hana, Maui, same thing.
Yeah. Government, let me put it this way, short answer, probably yes. And the court will not take a serious look in most circumstances unless you have evidence that it's pretextual.
Yes.
Daryl White says, how about deprivation of rights under color of law? I'm not sure what that is myself.
Well, that's the whole due process argument. And, and politically, again, that's the argument that a lot of people want to use, that their rights are being impinged. I mean, there are people who rightfully believe to themselves that the government can't do anything that impinges on what they want to do unless it harms someone else. There are people that won't pay income taxes because they think the government can't, order them to pay income taxes. Due process is a very important constitutional protection, but it has restraints. And I just say what I told you 115 years ago. The United States Supreme Court said that the government could force you to take a smallpox vaccine. It would be really interesting. I don't think you're going to get the same result if that case goes again. Let's assume there is a vaccine, Robert. And I know we're in the lightning round, but if there's a vaccine in January, do you believe that the government can force you or I to take that vaccine? I seriously doubt it.
Yeah, I mean, you will find, I think, people have already looked at that question on the Jacobson case, that 1905 case that you mentioned, Jeff, and have looked for ways in which to limit its scope or to limit it. In that case, it was a $5 criminal fine that the guy was challenging. Now, $5 115 years ago is a lot more, but it's still probably on the low end of things. They were not going to throw that fella in jail, as you mentioned in your response to the earlier question. But there were some consequences to that. Don't get the vaccine, guess what? You can't, well, back then probably not. You can't get on a plane unless you have the vaccine. And I think we're going to start seeing those. If the government simply says you are mandated or required with no exceptions to go get a vaccine, we're literally going to put you in jail because of it, I think that would be subject to a substantial challenge even under the Jacobson case.
I mean, just look at measles, for example, which is a highly contagious disease in which there's a vaccine. They can't force you to get a measles vaccine or deny you getting on an airplane if you can't prove you had a measles vaccine. So people have to just look at history, look at reality, and then to figure out where does the government's right to infringe upon your personal liberty take precedence over the health,
All right,
safety,
well,
and welfare. And there are 1,000 cases that deal with that every single day. And Robert deals with it sometimes dealing with takings.
well, let's go keep moving here. Chuck Thorne has a question. Can an employee who's afraid to come back to work, though we've done everything known to be safe, still collect unemployment?
I know that is a hot issue as to whether an employer can force an employee to come back to work. We've seen in other states, meatpacking and other facilities where the employees were ordered back to work and were threatened with their jobs. That hasn't happened. Here, I can just tell you, and not that there's been any threats, but our law firm is looking at how do we reopen and what options do we give people? And, you know, we're not going to order anybody to come back, you know, to the office. Now, you know, I think as long as some people are getting unemployment plus $600 a week, that could be an issue. When that runs out, it'd be a different story. I do think if you have a legitimate medical concern about coming back to work, I don't work for unemployment, but I would think that would be a legitimate qualifying factor, not a dequalifying factor. I don't know,
Okay.
Robert, how you feel.
Well, I want to move on here. Sorry.
Right.
The next one, Kristen Dobson asks, can a privately owned store require mask wearing even though it's a violation of the ADA? Or let's say a doctor says masks are bad for your health or something like that for a particular person. You know, can the store owners still say no to that person coming in their store?
Yeah, I mean, still the general rule is, right, even under public accommodation law, that the proprietor has the right to set certain conditions on service, as long as they're not the bad reasons prohibited by the public accommodations law. Now, you say you can't come in because you're a Roman Catholic who refuses to wear a mask. You got problems as the proprietor. No shirt, no shoes, no service. That still works, right, Jeff, under First Amendment?
Yeah, I think if the proprietor could show that what they're trying to enforce has a legitimate safety reason to other patrons or customers, you're out of luck.
Yeah.
In regards to traveling to Hawaii, Ali asks, can the state of Hawaii government actually place stronger restrictions on U.S. citizens versus foreign citizens?
I don't know the answer. I don't know the answer to that one.
I think it's the opposite.
Yeah, I mean,
I think they
intuitively,
can probably put a stronger restriction on foreign travelers than they can put on U.S. travelers, because as Robert just mentioned, there is a constitutional right to travel. And, you know, we saw in Rhode Island where they tried to shut the border for people just driving across. It was totally unenforceable. And again, it might get you a lot of votes, but it was an interesting concept. We saw what Florida wanted to do to stop travelers from New York. And now New York is talking about stopping travelers from Florida. I don't think you can stop travelers from any U.S. state into another U.S. state. You might be able to put restrictions on all 49 other states, but I don't think you can single out a particular state.
Yeah, I would agree. I mean, in Hawaii, maybe Alaska, just because it's distance and trouble, but we are relatively unique in that we are geographically isolated. And right now there's only one practical way to get here. And that's an airplane. So you adopt these regulations at the choke points and discourage people from doing it as opposed to making it illegal.
Well, there's a big crackdown now with the tourism. There's a big crackdown on short-term rentals, yet hotels and motels are still allowed to operate. Isn't that description a discrimination? And anonymous? That's an anonymous question.
Sure. You know, maybe I can answer that with a little bit of caveat. It was my law partner, Greg Kugel, who actually notified both the governor and I think it was the Big Island mayor last week or the week before that very distinction is problematic under the law. And all I would say to that is that the one thing that has, I think if you know, legally that people will learn or are learning right now coming out of this crisis is that in normal times, the government has the power to restrict your liberty, your use of property, and your business to an extreme degree already. And it's really not doing much more now than it could legally do before.
Yeah, no,
And these,
I think they can put the same restrictions on bed and breakfast that they put on hotels. I don't think they can make a difference. There's a huge enforcement problem. There are 100 hotels. There may be 10,000 bed and breakfasts and private homes that people are renting out. So I think there's no question they could say to someone who wants to operate a bed and breakfast, these are the things you have to do, and these are the same things that the hotels have to do. But how do you enforce it? And I think that's an issue.
right. And the challenge, before I want to be clear, that I understood that some of the challenge was saying, how come it's essentially a disparate treatment kind of argument, saying, how come you let the hotels open? Yeah, nobody's going to the hotels, but they're still open. And yet we, bed and breakfast owners, are similarly situated. Why were we shut down as a class? That distinction between us and hotels really doesn't make enough of a difference to support the government saying hotels are essential, bed and breakfasts and TVRs are non-essential and have to shut down. And the courts, unless there is no rational reason for the distinction, at least under federal law, the courts have said they will generally defer. And the one thing I did point out is that Hawaii law is a little bit different, because the Hawaii Supreme Court has said in a number of cases recently in the last 10 years or so that the government has to actually have a good reason for making those distinctions. And so I haven't heard coming out of the governor's office or the mayor's office on any county, well, what is the difference? Tell us what that difference is, and maybe the courts will uphold it or maybe they'll strike it down, but they haven't said, and I think that's a huge problem.
Okay, another person asks about a what if question. What if COVID was shown to be not as harmful as everyone thought? Then could they still continue these emergency powers? So let's say it was proven that it was as harmful as, let's say, the flu. Could the emergency power still be justified?
Yes. The statute says, and this is, I mean, I recommend you just go read chapter 127A of the Hawaii Revised Statutes. It says the governor or mayor, in terms of a local emergency, shall be the sole judge, and that's shall be the sole judge of whether there is an emergency.
I mean, it's no different than the president, invoking what's it called? The Defense Something or Other Act to force a business to change what they're manufacturing to manufacture ventilators or something. I mean, there's tremendous power. Yes. Folks, you're just going to have to understand this. You may not like it, but as Roberts pointed out, I mean, it's not unbridled. You can challenge and sometimes prevail, and the government has lost some of these eminent domain cases and some other very important cases where they've tried to impose things. But ever since Franklin Roosevelt, the power of the federal government is, and your state and local governments, depending upon whose hands it's in politically, they have tremendous power. So, who's to say whether COVID is serious or not serious or dangerous? As you point out, Robert, the governor just invoked emergency powers, and they have them. The legislature has given them that powers. Now, we can come up with scenarios. I know we're going quickly here, but we can come up with scenarios in which it's clear that the government can't justify what it's doing. But I don't think we're there here yet.
Another question from Kim Hain asks about schools. Do you think there's going to be lawsuits when the schools reopen? And what if schools enact forced masking and social distancing? And what if somehow that injures children and all of that? Generally, do you think there's going to be lawsuits coming out?
What if a parent doesn't want to send their kid to school?
Right.
Because they're worried about COVID, and then the kid is found to be truant, there's a lot of unanswered questions. I have no doubt that if the school wanted to require masks, they could do that. Now, whether a parent could then say, I'm not sending my kid to school is a whole other issue, but I don't have a definitive answer for that, Robert.
No, I mean, other than, if somebody asked me predict out of any circumstance, do you predict lawsuits? The answer is always yes,
Of course,
right?
too many lawyers.
There will be lawsuits. Will they have what they look like and whether they have a chance to succeed? Tough call. I think the baseline that the courts will be operating from, and again, I think Jeff and I are talking about the Constitution the way the courts actually enforce it, not necessarily the Constitution that he or I think should be the law. Let's make that clear. If we were the kings and the founders and adopting the Constitution and what it requires and limits, that might be another question. But what he and I are talking about is what we see the courts actually doing with these type of claims. So the short answer, I think, is generally yes, they can limit it. Lawsuits, for example, that challenges a child's inability to return to school because he or she doesn't want to wear a mask, say for religious purposes, that might have a better chance than a non-religious claim for that very same action.
And not to get technical, but people who know a little bit about the law, we get into strict scrutiny and intermediate scrutiny, and that's how all of these things are going to be looked at. And strict scrutiny is the highest, most difficult thing for the government to prove when they've made a distinction between people or activities. But most things fall under intermediate scrutiny, which is a very easy test for the government to establish.
Okay, what about ankle bracelets? Someone asks. Can island visitors be forced to wear them?
Go ahead.
Not unless they're on parole for a crime. Unless you make everyone coming through Honolulu Airport wear a bracelet for 14 days. No, you can't discriminate against out-of-state residents versus in-state residents on something like that. And two, I think the lawyers on this one would be salivating if the state adopted such a policy.
I mean, it's just like, give you an easier one, and I don't have an answer. Can the government require every tourist, forget about the quarantine, to call in 3 times a day as to where they are? Yeah. You have to call in after breakfast, after lunch, and after dinner. Where have you been? Who have you been with? It's dicey.
We've had, going back to schools, we've had about 5 questions here of people asking, can kids be prevented from going to public school if they do not get a vaccine?
Aren't they permitted now?
Or prohibited? You mean?
No, but aren't kids, I'm not aware of any law that, my child is way above that now, but I don't remember. I think they can ask if they've had a vaccine on public health forms, but I don't remember requiring that. Like measles or mumps or chickenpox, a lot of people don't believe in vaccine. Not a lot. Some people believe it's a government conspiracy or for health reasons, but I don't know the answer to that, Robert. Somebody that has a kid can say whether they have to say they've had a mumps vaccine before they go to school or a polio vaccine. I don't think so, Robert. I don't know.
I don't know the answer to that.
Sorry.
I know for for instance, public schools in the state of New York require you upon pain of unenrollment if you do not provide a immunization.
Some of the attendees are saying you can actually go to school without vaccines in Hawaii, but you have to have a religious or medical exemption.
Okay, good. Yeah, I didn't know the answer to that.
Good, yeah.
But anyways, there's way too many questions for us to get to right now. Let me turn it back to Keli'i, and I do apologize if we weren't able to get to your questions.
If we get paid double, we can come back another time.
What's twice of nothing?
That's my point. Yeah.
You've done a terrific job, Jeff and Robert, and I want to give you just a moment to let people know how to get a hold of you if they'd like to follow up and ask you any questions or talk with you at all. Jeff Portnoy?
Well, I'm at Cade Schutte, and you can find us on the web, www.cades. I don't have a problem with emails, jportnoy@cades.com. If it doesn't go into junk mail, I'll certainly try to acknowledge it. And I appreciate the opportunity to be on today, particularly with Robert, who I really respect and admire.
Well, thank you for being on the program. And Robert Thomas, how do people get a hold of you?
Best way to find me is at my blog. It's www.inversecondemnation. So INVERSECONDEMNATION.com, or RHT, my initials, at hawaiilawyer.com.
I want to
thank
know
you.
why you're in California. That's what I want to know.
I
We
was
can talk
here. I
about
was
that
here when the
offline.
whole thing hit.
You're not prepared for 14 days in quarantine. Sorry, Khalid.
No problem, no problem. Well, it's great having both of you, and we appreciate your consultation. We appreciate your insight, and look forward to having you on board with Grassroots Institute again. And Joe Kent, thank you very much for managing
Thanks,
questions. My apologies to those of you who didn't get your question asked and answered on the program. We just had such huge participation today, and feel free to follow up with either of these attorneys directly, and I'm sure they'll be glad to respond to your question. Thank you. I'm Keli'i Akina. Until next time at the Grassroots Institute, aloha, everyone.
Bye. Thank you.
Bye.
Bye-bye.
Bye, everyone. Thank you.